Now we're going to move on to really a bit of a link-in to one of the crucial issues that is high up the European agenda, which is the whole question about sustainability and stimulating green technology. And Marc Steiner, who's a judge from the Federal Administrative Court in Switzerland, but also a significant expert on European public procurement, which I know he's studied for many years, including working in the European Court of Justice, is going to talk about sustainable public procurement. And I might also just add, for the benefit of the audience, that, of course, a number of members of the European Economic Area, including Switzerland and Norway in particular, also sign up to the acquis on European public procurement and have a great deal to contribute to that discussion. So we had a very productive visit to Switzerland last year as a committee, and we're very delighted to welcome you here today to share your expertise with us. Mr. Steiner.
Mr. Chairman, Madame le Rapporteur, ladies and gentlemen, I feel deeply honored, and it's at the same time an utmost pleasure to speak to you about a more and more important issue. What I'm expressing is a personal view, especially not binding the Swiss government in any way. The concept of sustainable public procurement has undergone a long way to become more or less mainstream as it is considered today. As far as the relevant documents concerning the future of public procurement are at stake, there's no need, as it would be back home in Switzerland, to with your own document, such as the report on new developments in public procurement, the Green Paper on the modernization of EU public procurement policy, and last but not least, slide 7 please now, the Single Market Act supporting a view, I quote, underpinning a balanced policy which fosters demand for environmentally sustainable, socially responsible and innovative goods, services and works, end quote. I will therefore also in the following minutes skip some slides in order to remain within the frame of an 8 to 10 minute statement. As it is said in the Green Paper, slide 3 please, the first objective of public procurement is to increase the efficiency of public spending, normally called best value for money. But there is already a first important step to make in this context when thinking of what public procurement is really about. Best value for money is the relation of the balance between quality and price and does not mean to ask for the lowest price only. So in Switzerland we say, unlike the wording of Article 53 of the Directive 2004/18 EC, that to ask for the economically most advantageous offer is the rule, and to ask for the lowest price only is the exception, which only applies for standardized products where there's nothing to say about the quality. The more complex the demand of the public authority is, for instance when dealing with services, the more obvious it is that you won't get the best solution if the price is the only relevant aspect. But let us now turn to the more specific issues about the integration of so-called secondary or horizontal policy goals. In the Green Paper, slide 5 please, it is said in this respect that the complementary object is to allow procurers to make better use of public procurement in support of common goals. These include the protection of the environment, combating climate change, promoting innovation and social inclusion. Here the message is also, as it is in the context of the notion of economically most advantageous offer, that public procurement is not only about money. That's what's basically said in the Helsinki bus case by the Court of Justice of the European Union. Next step has been the EVN Wienstrom case, where it is stated that procurers can ask for renewable energy sources in the award phase. So the conclusion is, as far as the relevant aspects are product related, you can use public procurement to assure consistency between economic considerations and sustainability goals. You know better than I do that this philosophy inspired the directives 2004/17 EC and 2004/18 EC. But this is also true, and what's important for the international trade law, especially the WTO Government Procurement Agreement. There's obviously an interaction or interplay between WTO government procurement regulation and EU public procurement regulation. Let us therefore have a look, slide 9 please, at the relevant treaty. The central premise of the GPA is non-discrimination in government procurement between signatories. This approach is more or less comparable to the market opening aim of the EU public procurement regulation, even if the GPA regulation is less comprehensive compared to the EU directives. So what's clear is that the GPA rules are basically, they want to prevent old-fashioned protectionism. Now, there is true that also sustainability aspects can be used to foster blunt, old-fashioned protectionism, and therefore there must be set some limits in world trade law and in domestic procurement law as well. But at the same time, there can be seen a mindset change inside the WTO, which is very important. Very interesting maybe in this context be a statement of Director General Pascal Lamy at the occasion of the last GPA symposium in February 2010, where he said, "The mere removal of obstacles to trade may not by itself ensure optimal performance if rules are not in place to ensure responsible, quote, responsible competitive behavior that is environmentally sustainable." So they seek a balance between trade law and sustainability goals. For the WTO, this is really new. Views like this make it understandable that no one did complain in the WTO context about Article 26 of the Directive 2004/18/EC dealing with the contract performance conditions. To prove that trade law doesn't prohibit the implementation of secondary or horizontal aspects, let us turn now to a social problem, knowing that there is nowadays a rather broad consensus that environmental aspects are, from a legal point of view, much easier to implement within a public procurement context than social concerns. The social standards which I would like to address to are the ILO core labour standards. These deal mainly with child labour and forced labour. According to the relevant recital, please go to page 17 of the Directive 2004/18/EC, contract performance conditions as described in Article 26 of the Directive, I quote, may refer to the provisions of the basic ILO conventions, end quote. If GPA specialists would have continued to defend, as they did 10 years ago, what was prescribed as purity principle, which means that one purpose of public procurement regulation would be to establish a system that reduces as far as possible the insertion of non-economic criteria into the procurement process, then the implementation of ILO core labour standards would probably, if at all, only be admissible or possible within the context of contract performance conditions. But this is not the way the Directive 2004/18/EC does interpret the GPA. Article 45 of the Directive, for instance, provides that the tenderer shall be excluded from participation in a public contract if he is convicted for money laundering. The same is true from the ILO perspective about ILO core labour standards. Switzerland, wanting to avoid contradiction in its own behaviour, can therefore not disregard the distorting effects of a bidder's behaviour, taking advantage of not respecting ILO core labour standards when producing abroad. That's why the non-respect of ILO core labour standards is, according to the new Swiss regulation, not considered as a problem to deal with when defining the contract performance conditions, but as a reason to exclude non-compliant bidders. The relevant provision reads as follows. If the subject of the contract is a task to be performed abroad, the bidder has to assure at least the respect of the ILO core labor standards. This leads not only to more coherence within the sustainability concept, but more than this, Switzerland does hereby behave as if Article 7 of the Treaty of the Functioning of the EU would apply, saying that the Union shall ensure consistency between its policies. And this, slide 25 please, and this is the real take-home message of the statement you are listening to. The existing conflicts between sustainability concerns and trade or internal market law need to be resolved if international and EU law are to provide a reliable and credible system of norms. Thank you for your kind attention.
Well, thank you very much indeed, both for being exactly on 10 minutes, but also for providing a very precise and a very well-targeted set of presentations. And also we have the supporting slides as well. So thank you very much. And thank you also to our slide changer, who coped extremely well with shuffling between your slides in a very expert way. So I hope that the people watching outside saw that also. And we're now